Got another bad ruling to tell you all about. The fight for the Second Amendment just took another major legal smack, another big roadblock. But it's one that I think ultimately will be rectified. A federal appeals court just ruled against a challenge to the National Firearms Act. They ruled to uphold restrictions on short-barreled rifles. What does that mean for gun owners? What does it mean for the ATF? For the future for gun control in America? Well, stick by because I'm going to break it down for you right now. Before I get into it, if you're passionate about protecting the Second Amendment and staying informed on the latest gun right news and whatever else comes out, then make sure to subscribe to Guns and Gadgets. I'll bring you all the stories that the mainstream media will not cover, and we need patriots like you in this fight. But first, a huge shout out to today's sponsor, Attorneys on Retainer. If you're serious about self-defense, then get serious about defending yourself with Attorneys on Retainer. AOR is not backed by any insurance company. They are a real law firm, so they don't have to follow the same restrictions and limitations as other insurance-backed companies. Plus, they are the only law firm that only deals with self-defense cases. AOR will defend all types of criminal cases, so they don't deny coverage. And your attorney-client privilege starts immediately because attorneys are answering the emergency number for members when they call. If you can reasonably and in good faith assert that you acted in self-defense or self-defense of others, they'll cover you. Plus, if you join now, I can save you $50 off your individual sign-up fee or $25 off your family plan to help you sign up and save some money. But you got to use the link down below and enter my code GNG. Get serious about your own self-defense. Get Attorneys on Retainer. Guys, I've spent time with them. I just got back from Phoenix to spend time with them as well as speaking at an event. I broke bread with them. They're truly, truly good people who believe in defending those that defend themselves or others. All right, let's dive into this. A man named Jamond Rush was charged with possessing an unregistered short-barreled rifle, which was an AR-15. I believe it was an Anderson, and it was a 7.5-inch barrel on that bad Larry. Now, if you know your gun laws, then you know the National Firearms Act of 1934 requires that certain firearms, including short-barreled rifles, must be registered and taxed. It's unconstitutional, doesn't pass the muster if you ask me, but if you were asking Jared, things would be a lot different anyway. Well, Rush challenged this in court, arguing that these restrictions violate the Second Amendment, especially after the Supreme Court's landmark decision in Bruin. His argument? The NFA's registration and tax requirements create an unconstitutional burden on law-abiding gun owners, restricting their right to keep and bear arms. But here's where it gets interesting. The court wasn't buying it. They ruled that the Second Amendment does not protect unregistered short-barreled rifles, and they leaned on some old Supreme Court precedent to make their case. Now, this isn't the first time the NFA has been challenged. Back in 1939, the Supreme Court ruled in U.S. versus Miller that short-barreled shotguns weren't protected under the Second Amendment. The government used that decision here, arguing that Miller is still good law and still applies today. Well, the court said if Miller ruled against short-barreled shotguns, then the same logic applies to short-barreled rifles. But hold on, doesn't Bruin change everything? Did they even hear about the Bruin decision? Well, ever since the Bruin decision, courts are supposed to analyze gun laws based on historical tradition, meaning the government has to prove that a modern-day gun regulation is consistent with how firearms were regulated back in the founding era. Remember that in Bruin, the Supreme Court established a two-step test for evaluating Second Amendment challenges. First, courts must determine if the conduct the government seeks to regulate is protected by the plain text of the Second Amendment. And second, if it is, then the government must demonstrate that it is a regulation that's consistent with this nation's historical tradition of firearm regulation. Well, the problem here is that the court said the short-barreled rifles fail that first step. And according to the judges, the short-barreled rifles are not in common use for self-defense. That doesn't matter. And even if they were, they said that history is full of gun restrictions that regulated concealable and dangerous weapons. Now, they pointed to laws from the 1600s that regulated musket barrel lengths, laws in the 1800s that taxed and registered firearms, and even surety laws that required people prove that they were responsible before carrying weapons. And then one of the judges even said the NFA is just a modern version of these historical regulations, which I think is extremely inaccurate. So according to the court, the NFA's registration and taxation requirements are nothing new, and they rule that Bruen doesn't change that. Now, this is a big deal. It means that for now, the courts are standing by the NFA, keeping short-barreled rifles under strict regulations of registration and taxation. And if you want to own a short-barreled rifle, then this ruling reinforces that the ATF demands that we plebes follow the rules or risk ending up like Jamon Rush. Remember, the penalty for an unregistered short-barreled rifle is up to 10 years in federal prison and a $250,000 fine. Now, this also shows that Bruen isn't a free pass to overturn every single gun law. Lower courts, like this one, are still using old Supreme Court cases like Miller to justify gun restrictions. But here's where the real question is. Will the Supreme Court step in? Will this be appealed to the Supreme Court first? And finally, will the Supreme Court rule on the NFA once and for all? If they do, it will change everything. Not could change everything, it will change everything. And you better believe that we'll be watching. Now, the fight for our gun rights isn't over, guys and gals. Doesn't matter who the president is. It's not over by a long shot. We need strong legal challenges to push back against these unconstitutional laws. And that's why I want to give a huge shout out to you, America. You all are the ones who are keeping the pressure on your legislators. You're doing the work, and believe me when I tell you, when I speak to people on Capitol Hill, it's making a difference, so please don't stop. Patriots, the Second Amendment needs you. Help us get the truth out by hitting the like button, subscribe, and stay updated, and share this video so that more people know what's going on. What do you guys and gals think about the NFA's registration rules? I know what I think. I want to hear your comments though. Drop it down below. I can't wait to read them. This should be great. Stay armed, stay informed, and I'll see you on the next one. God bless America. It's just a bump in the road, but it's a big bump. Take care, y'all.